Okay, so today we're going to talk about my new DUI book geared towards Washtenaw County. You can see it's called Leaders and Best, Washtenaw County DUI Defense. So I live in Ann Arbor. I went to the University of Michigan for law school. Most of my cases are probably in Washtenaw County, so this is a book that's important for potential clients to take a look at. A lot of information in here, and I want to go through a PowerPoint on some things I cover in this book and things to consider. So the first thing is, who am I? As I mentioned, University of Michigan Law School, passionate about the university and everything about it. Also a former prosecutor, New York City. I was a prosecutor here in Michigan and Oakland County. The dad of 2 young children, hockey coach, and an author. This book is one of 9 books I've written on either DUI cases, proactive defense, love educating clients, other attorneys, just writing about what I'm passionate about, which is helping clients. So what are we going to cover in this presentation here? We're going to look at all the Washtenaw County courts, the judges, the timeline of a criminal case, the art of DUI defense, the 3 windows, which we'll get into, deal or no deal, and in some cases, an implied consent. So here are the judges for the 22nd Circuit Court. There's 5 Circuit Court judges here. Not all of these judges handle criminal cases, but they rotate. So any of these judges could be on a criminal case in Washtenaw County. A DUI in Washtenaw County will go to the felony level at the circuit court if it's a 3rd offense, or if a serious injury has occurred or a death has occurred because of a DUI. Most DUI cases do not go to the circuit court, but if you're charged with a felony, your case may be handled by one of these 5 judges. That's after the case is at district court level. Most cases in Washtenaw County will go to the district court level. And here in Washtenaw County, there's 6 courts. Anything in the city of Ann Arbor will go to the 15th District Court. You can see that Ypsilanti Township and the city of Ypsilanti have 2 different courts there, 14B and 14A2. And then the 14A1 court in Pittsfield Township. And then we have the Chelsea and the Saline court. So there are smaller villages and cities within some of these courthouses, but you'll have to look on your ticket and we can figure out where your case is going to be. Here we have the judges, the many personalities of Washtenaw County. And we see that there are 12 judges here. Some of them are the district court judges, some of them are circuit court judges. All of these judges, in my experience, are very fair. All these judges are very considerate. All these judges are very intelligent. All of these judges are looking for clients to distinguish themselves before their bench and make the best impression possible. So when you hire an attorney for your Washtenaw County case, you need to be thinking, does my lawyer know the judge? Not, needs to be best friends with them, needs to hang out with them, needs to call them, the greatest friend ever, but someone who practices before them, who knows their ticks, knows their strengths, weaknesses, things that they're looking for. How do we make the best impression on the judge in your case? So once you have the court you're at, we'll talk about which of these judges could potentially be in your case and what we should expect working with them. So the timeline of a criminal case for Washtenaw County. Most DUI cases, I'd say 98% of them involve a police officer pulling you over. Lights go on, sirens go on, you pull to the side, police officer comes to the window, you eventually get out of the vehicle, perform some tests, and you're arrested. That's a very common way a drunk driving case happens. Some cases involve a traffic accident, a police officer shows up, there's an accident. After observing a bit, having conversations, then it becomes a drunk driving investigation. Some cases involve the client being pulled over on the side of the road in a parking spot. So your first interaction will be with the police. Next, the case will go to the prosecutor, who will review the evidence and determine what the charge actually is. So it's possible that the police will issue you a ticket that says operating while intoxicated, visibly impaired, super drunk, whatever they're going to issue. But ultimately, the prosecutor is the one that brings the charge and the case against you. When I was a prosecutor in New York and in Michigan, I would receive all the evidence from the police department, review everything, and make a determination on what the charge would be. The charge can be drunk driving, but there can also be other charges such as driving while license suspended, or if there was some sort of resisting arrest with an officer. Depending upon what the facts of the case are, the prosecutor will make that decision. In a lot of cases, the prosecutor will then give the case back to the police officer, who will go to the courthouse before the judge and have a warrant sworn to, telling the police officer the facts of the case. Court says, okay, that sounds like a criminal case. This person's not guilty yet. They're not guilty yet. But okay, this sounds like a case. Sounds like we need to kind of figure this out. So the court's the last part in that timeline of charging you. Ultimately, the place where you'll be once charged. So the art of proactive criminal defense. So you can see on the bottom here, this is my book I wrote specifically about Ann Arbor Criminal Defense Playbook, Insider's Guide to Washtenaw County. You definitely want to read this if you have a drunk driving case in Washtenaw County. Then I have The Art of Proactive Criminal Defense, which is a book that goes deep into how being proactive can benefit your case and your life moving forward beyond this case. In this ART, arrest release track, we talk about the opportunities that you have in order to impact your case even before going to the courthouse. What can we learn about your arrest? What are things that we can challenge, learn more, explore, build some leverage within your case into what happened at the arrest? The release portion, are you aware if you're testing for drugs, for alcohol? Do you know when your next court case is? Do you know your bond conditions? Are you allowed to drive, travel? What are your obligations to the court? If you don't take this part seriously, you can go to court and they can say, well, you haven't been testing, or you couldn't leave the state, and the person's surprised, but they simply didn't understand their obligations to the court. The tracking is where an attorney can really make a difference. A lot of drunk driving cases, there's not a known court date on day one. An attorney could figure out when the first court date is. If blood needs to be tested, there could be a delay, but a warrant could be issued for your arrest. You don't want to be in a situation where you're simply sitting back saying, well, I know I'll be charged with a drunk driving case. Not going to happen today, not going to happen tomorrow. Put it off to the side. You need to be focused and dialed in on day one. So as you can see here, police, prosecutor, and the court are working together to prosecute you. They're doing their job. They're getting paid every single day to prosecute your drunk driving case and move it to the next level. You should be an active participant in your case as well. Being proactive on day one, in my opinion, as a former prosecutor and someone who does this for thousands of cases, is the right approach, and the approach that gets you the best results and the best long-term success for your case. Next, we have here the 3 windows of review. And here I have the Michigan DUI playbook, which is kind of my foundation for everything I do in a drunk driving case. We look at 3 different ways to potentially attack your case in the courtroom. This is beyond being proactive. This is how do we beat your case? How do we create leverage? How do we tell the prosecutor, hey, your case is not as strong as you think it is? First, we look at first contact with the police. Does the prosecutor have reasonable suspicion within their case? Did an officer have a reason for pulling you over? If you went through a red light, you're speeding, if you hit the curb, if you were swerving outside the lanes, is that reasonable suspicion to pull you over? Is your car on the side of the road after a traffic accident? Those are reasons why a police officer can interact with you and start building their case against you. You driving away from a bar, not violating any traffic code, but the police officer says, hey, that person's probably drunk. That would not be reasonable suspicion. Unfortunately, a lot of clients reach out and say, hey, I think the officer pulled me over because I was leaving the bar. Then we look more in the report, well, that car was swerving or speeding or didn't use their turn signal. Even if the reason for pulling you over is because you're leaving the bar, if you break any traffic code, well, they can pull you over. The next is the basis of the arrest. Probable cause to arrest. Does the officer have enough to say it's probable this offense was committed? They need basis that you were operating a vehicle, and they need basis that in some way you're impaired, intoxicated, or giving indication that you have been drinking and that alcohol has reached a point where it's probable that it's against the law. Now, a police officer can arrest you even without probable cause, but that's where your lawyer comes into play. If there's a basis for a motion and a hearing, a judge could decide, you know what, the officer didn't play by the rules, I'm going to toss the case out. And we get to that point because anything after the arrest would also be tossed out, such as the chemical test. So if an officer says, hey, you didn't have probable cause to arrest the client, well, then the data mass or the blood test would not come in. Therefore, there's no case to prosecute. Finally, the elements of the crime. Now, in drunk driving cases, in my experience in New York and in Michigan, most drunk driving cases have some evidence that the person was driving a car and evidence that in some way they were over the legal limit or had impairment in their driving. So most cases will have the element of the crime, but there are certain drunk driving cases that may not. Those could be cases especially that are right near the legal limit. Those could be cases where there's a question about the person driving the car, such as a traffic accident, or there was two drivers, some sort of reasonable doubt that the prosecutor cannot prosecute their case. Now, if there's an issue with the elements of the crime, it doesn't mean that you should run and set your case for trial. Sure, that could be an option, but a lot of times, this right here, number 3, can be used as leverage with the prosecutor. The prosecutor says, hey, you know what? My case is not as strong as I thought it was, and you can work out a really good deal, not because you didn't commit the offense, but because the prosecutor can't prove you did. Here we have deal or no deal, and it comes down to what is the best approach and outcome for your case. We look at many things here. The first is the case itself, traffic stop, accident driving, field sobriety test statements, what the officer observed in his knowledge, and the chemical test. How strong is the case against you? When I was a prosecutor in New York and here in Michigan, I'd open up a file, look at the police report, look at the evidence, and say, hey, this is an easy one. I'd prosecute this case in 15 minutes. There's no doubt about it. Sometimes you pop it open and say, hey, you know what? There could be some issues here. So as a former prosecutor, it's very important that myself and my client talk about this here. How strong is the case? Then we look at what is your prior record? Is this a first offense, a second offense, a third offense? Do you have a history of alcohol offenses? Will a judge hold it against you and consider this a pattern? What can we anticipate from the judge in your case? Driving record, what's going to be the impact on this case that coincides with what you've done in the past? Your driver's license, the ability to drive, that needs to be a factor. What is your career? What is your family situation? What are your goals in life? Certain professions in the medical field, or attorneys or teachers, different CDL drivers, they have different responsibilities and different requirements for being charged with a drunk driving offense. And it's important to discuss going forward. Will you be able to keep your job? Will you be able to drive a car? Will you be able to keep your job and your livelihood? We need to factor all of that in, deciding deal or no deal. Now, by being proactive, it's our hope that we create enough leverage with the prosecutor and the judge in order to get the maximum best result for the situation that we're in. Of course, we can't change what happened out in the road, but we can impact it by our actions. So by creating the best possible deal, we can evaluate that against what's our likelihood of prevailing at trial. It could be a no deal. Is it deal or no deal? Finally, we talk about the implied consent. Now, this is only going to be in about 5% to 10% of drunk driving cases. This is a factor when you refuse the chemical test and a police officer had to obtain a warrant to draw blood. Now, if that seems something foreign to you and say, that didn't happen, you don't need to hear about this. But if this does apply to you, it's very important to tell your attorney right away, I think I have an implied consent issue. I need to appeal that within 14 days. I need a car. What can we do? In the past, I've been able to have really creative solutions here, and we can talk about that more in terms of keeping your driver's license, or we go the hardship license route. Our goal here is, if you have an implied consent issue, to put you on the path where a judge or a prosecutor or a police officer are going to say, hey, you know what? I'll give that person a chance to keep their driver's license and maintain their ability to drive a car. That's what we want to achieve. So if you have this issue here, the implied consent, very important to tell your attorney. Finally, if you're charged with an offense in Washtenaw County, a drunk driving offense, or you know someone who is and you watch this video, please feel free to reach out to me. I'd be happy to discuss options, goals, and a pathway to achieving those goals.